Good morning, this is your Kelso Report for Friday, July 20th, and I'm your host, Clark Kelso. We begin today with a Ninth Circuit case involving education law and the Individuals with Disabilities Education Act. In Anchorage School District versus MP, the Ninth Circuit reversed the district court's judgment that the school district did not deny a special ed student a free and appropriate public education because, in the district court's opinion, the parents were too litigious. The Ninth Circuit explained that penalizing the student's parents for exercising the very rights conferred upon them by the Individuals with Disabilities Education Act undermines the statute's fundamental purposes. The Ninth Circuit then reviewed the record itself instead of remanding, and concluded that the district court had in fact that the school district had deprived the student of a substantively adequate, free, and appropriate public education by relying upon an outdated individual education plan to measure the student's academic and functional performance. The court ordered the district to update the plan, and the court concluded that the parents were entitled to reimbursement for private tutoring expenses. Parents are not going to be penalized under the IDEA for being too litigious, for being too strong an advocate for their children, essentially. Next, we have California Supreme Court taking another look at what constitutes burglary. In People v. Yarbrough, the California Supreme Court addressed the issue of whether burglary is committed when the defendant climbs onto a second-story apartment's private balcony, which was surrounded by a metal railing some 4 feet in height and accessible normally only through the single-bedroom sliding glass door. Now, as you know, burglary, according to Section 459 of the Penal Code, is committed when a person, quote, enters any building, close quote, with the intent of committing larceny or any felony. About 10 years ago, in People v. Valencia, the California Supreme Court held that a building is entered when the building's outer boundary is crossed, and a building's outer boundary encompasses any element that encloses an area into which a reasonable person would believe that a member of the general public could not pass without authorization. Well, the jury convicted the defendant under this standard, but the Court of Appeal reversed, stating that an unenclosed balcony is not within a dwelling's outer boundary. Well, the Supreme Court disagreed with that on the facts of this case, concluding that the second-story balcony, surrounded by a 4-foot-high railing, where the balcony was intended to be an extension of the living space, in this case a bedroom, that is within the apartment's outer boundary. And the jury properly convicted the defendant of burglary. I suspect this hypothetical will show up on law school exams around the state. Next, we have a question of what constitutes or who can be awarded good conduct credits. Effective January 25, 2010, the legislature increased the rate at which prisoners in local custody could earn conduct credits against their term of confinement for work and good behavior. But the legislature withheld this possibility of early release from any prisoner who was required to register as a sex offender, was committed for a serious felony, or had a prior conviction for a serious or violent felony. In People v. Lara, the Supreme Court of California granted review to decide whether a court may award credits at the increased rate to a categorically disqualified prisoner simply by ignoring the disqualifying acts, pretending they didn't exist. The defendant contended that the court has that authority as an aspect of its discretionary power to dismiss a criminal action in furtherance of justice. Well, the Supreme Court disagreed with that unanimously, concluding that nothing in the applicable statutes authorizing the award of increased conduct credits or the authority to dismiss a criminal action in furtherance of justice, conferred that type of discretionary authority simply to ignore of the facts on the superior court. To the contrary, it was perfectly clear in the statute the legislature did not want such credits awarded to inmates who fell within the statutorily defined categories. That's it for today's Kelso Report. Have a great day in the law and a good weekend. See you next week.